Are we? Oh, we are. Good afternoon, everyone, and welcome to the Electoral Area Services Committee meeting for Wednesday, October 2nd. I'd like to acknowledge that we are on the territory of the Coast Salish people, and I'm looking for an approval of the agenda with R16 is being pulled, and R2 has been revised and republished. The updated version is in your agenda. So with those two changes, it's been moved and seconded. All in favor? Any opposed? Motion is carried. Moving on now to the Electoral Area Services Committee meeting of September 18th. Recommendation?
Thank you, Madam Chair. The recommendation is that the minutes of the Electoral Area Services Committee meeting of September 18th, 2019 be adopted.
It's been moved. Second? Any question? All in favor? Any opposed? Motion is carried. Moving on now to 3, is there any business arising from the minutes?
Thank you, Madam Chair. There is none.
Now we'll move on to the public input period. Is there anybody wishing to speak at the public input? And the policy is on the screen. Welcome.
Good afternoon, Madam Chair. I'm Cliff Evans from Shawnigan Lake. Madam Chair, on today's agenda, there are 4 soil deposit bylaw permits up for approval, and 2 of those seem to be quite clear, no problems at all. But on permit number 8 and 9, there's a few permits in that we have a few problems with the permit. In that, at site number 8, we have a resident with 16 times the lead in her water that she should have. We've informed VHA and Ministry of Environment about it, and so they will be investigating. On site number 8, they're bringing in hundreds of tons of hog fuel. And I see, if you read the definitions in the soil bylaw and read them very carefully, you'll see that there's no wood or hog fuel allowed at all. And where you find that, if you look under soil, it looks benign. But it says, or other material for dumping. And other material includes, but is not limited to, construction, reconstruction, renovation, building, demolition, and road work wastes of any nature, hog fuels, edgings of other work, wood waste, which result from the manufacturing process of lumber or other wood products. And so if there's any of that going in, that should be put into a waste site. And no person shall cause or permit the deposit of other material on any parcel within the electoral area except as permitted under a facility license issued in accordance with CVRD bylaw number 2570
You have just a few seconds.
Waste Stream Management Licensing Bylaw. I don't believe that the CVRD has issued any of these sites a waste facility license, and I would hope that when you come to these items on the agenda, that you would either refer them or stop them immediately. Thank you.
Thank you, Mr. Evans. Is there anyone else that wishes to speak to the group today? Welcome.
Hi, my name is Elizabeth Brennan. I'm the unfortunate neighbor of the soil site on Goldstream Heights. Sorry. We've been dealing with the noise, trucks coming all times outside, even the bylaw that's been created between 7 and 7. And the site has been registered as a contaminated site. Now our water is contaminated 16 times the level. So I'm in communication with the BHA, 2 different levels, as well as the MOE. I ask that you deny that permit or defer it at least until all of the people involved and looking into it finish their investigation and decide what needs to be done. Thank
Thank
you.
you so much. Is there anyone else that wishes to address the committee?
Bernie Yearling.
Welcome.
Mill Bay. The soil bylaw officer informed the Brennans to contact the Shawnigan Basin Society, of which I am a member. So the site next to her on Goldstream Heights has been designated a contaminated site in 2012 by the Ministry of Environment with exceedances in metals such as lead, arsenic, chromium, copper, as well as exceedances in polyaromatic hydrocarbons. So I don't think the policy should be to add fill on top of a contaminated site. The contaminated site should be remediated. The other application for a permit, that is the ASI site on Stebbings Road, also in 2012 was demonstrated to exceed the allowable limits of metals and polyaromatic hydrocarbons. And again, I don't think you should be adding fill onto a contaminated site. The site should be remediated. The third comment I have is for the development proposal on 1080 Shawnigan Mill Bay Road, there is a bit of a sin of omission where they point out that the APC basically said to go ahead with the development. The APC motion actually was a conditional motion, and the condition was that if there were proper water sources for development, then the development should go ahead. And at the time of the meeting of the APC, there was inadequate water supply, and what water was found exceeded the allowable limits of manganese. So I think this should be clarified. Is there adequate water before this development is approved? Thank you.
Thank you. We have a few more minutes. Is there anyone else that wishes to address the committee on any subject that we're having today?
Good afternoon,
Good
Madam Chairman.
afternoon.
My name is Ed Weeb. I'm a Shawnigan Lake resident.
Welcome, Mr. Weeb.
I was at that particular site 2 days ago, and I just want to also confirm that I don't think this is a site that should be filled with hog fuel on top of contaminated soil, and also this is not the appropriate place for hog fuel to go, not in that massive volume that's there. Thank you.
Thank you. A few more minutes. Welcome.
Thank you, Madam Chair. My name is Kirk Tusaw. I'm a resident of Duncan. I'm here to speak about the CVRD proposed cannabis production bylaw. Thank you for the opportunity to comment and for taking this important step forward for a nascent yet burgeoning legal cannabis industry that's going to provide tremendous economic opportunity, particularly to farmers in this community. I have 4 discrete changes that I'd suggest to the policy, all designed to allow for small craft farmers to have an easier opportunity to move through both the municipal, provincial, and federal licensing processes First, I think the policy should be clear that micro-cultivation in particular, this is small-scale indoor or outdoor production, ought to be permitted in all agricultural zones in the CBRD. Second, I would suggest that you change the language regarding setbacks from other zones to have the effective 300-meter measurement be from the portion of the lot that is licensed by Health Canada for cultivation, the actual production site, not from lot line to lot line. And the reason for this is, if, in particular, if you have a small, under 1 acre or 2,000 square foot micro-cultivation license on, say, a 30-acre property that borders a residential zone, you need to be, your property needs to have a 300-meter setback under the proposed policy, and that obviously wouldn't happen. But your site may well be well over 300 meters away from the actual residential zone, and separated by forests, separated by other land. And so I think that something more similar to the usage to the lot line makes a bit more sense. And I have specific language in a written submission that I'd ask your permission to hand up. Third, I think that the policy as written would act to potentially prevent farm gate sales of cannabis grown on that farm to the retail consumer at that location. I know that that probably isn't the intention. The intention is probably, if you have a retail store, we don't want you to have a grow, in the attic above it. I don't think that would be permitted by Health Canada, but I think that was sort of the idea of the ban on production sites at existing retail stores. Unfortunately, the way it seems to be written would also capture retail sales by the farmer of products grown on that farm, something that the BC government is encouraging, something that Health Canada is encouraging in order to assist the micro-cultivation, the small craft farm industry. And then finally, and I think this is a very crucial change for ease of farmers' abilities to navigate this system.
Your time is up.
Might I finish one sentence?
We'd have to have everybody, okay.
Remove the requirement of a fully completed Health Canada application being in place prior to applying for rezoning. That, I think, puts the cart before the horse. And if I could just hand these
Actually, give them
forward.
to the side table, please, and for staff, and staff.
I will
can
do
hide
so.
your
Thank you
mic
for
at
the
that time.
opportunity to
Okay.
make submissions.
Thank you. How many more minutes do we have left in this? Welcome.
Thank you. My name is Sarah Campbell. I am also a resident of Duncan, and I'm here just to give a little bit of feedback on the cannabis production facility land use application policy. Thank you to the board for putting this forward. I wish we had a little bit more time to have some consultation. That would be something I would maybe request moving forward, but really appreciate the opportunity here. I am a director of the Craft Cannabis Association of BC. We represent small independent farmers across the province. Two specific points I just want to address are, I look forward to what you will see in your requirement 1B, 4, and 5 regarding the relevant socioeconomic information regarding the cannabis production facility. I think that these micro cultivation and processing operations are really integral to our communities, and I think that with further consultations, we can show how food security, being one of the major concerns, can actually be alleviated through incorporating cannabis as a diversified crop to small farmers. Farming is difficult these days, and any way we can encourage our agricultural land to be used for farming, I think is to be encouraged. And point 2B regarding farm gate sales. However we move forward here, I think it's just very important that you all understand that farm gate for the small farmer is an ideal business model here in the Cowichan Valley in particular. Nelson currently is undergoing, or the Kootenay region is undergoing pilot projects because the provincial government recognizes the importance of that industry to that region. It is the same here in the valley. I'm sure many of you know this, But anything we can do to nurture this, and Farmgate in particular is of course going to reduce margins or increase margins for farmers. And it's going to encourage local, buy local. I've seen lately the dairy farms in the Cowichan Valley have introduced farmgate sales, and I understand that this has made the community excited. They're increasing their business, their sales. This is extremely important to the micro farmers in particular, the small scale farmers moving forward. And I just ask you to consider that in the future.
Thank you so much.
Thank you.
We have 1 minute left, so if someone has something, we have a minute left in our 15 minutes.
1 minute.
Yes, welcome.
Hi, welcome. Thank you for having me. This is related to the cannabis production facility land use. I'm excited about this tremendous opportunity to be able to move forward and speak on this topic. I am a longtime educator of children, connecting children to school gardens, and I have just relocated to a 22-acre property, which is currently fallow and has been for years. I want to regenerate the soil. My vision is to start a small-scale farm, employ 2 to 4 local people interested in learning about sustainable farming. I would like to micro-cultivate cannabis as well and craft grow outdoor up to 1 acre of cannabis to supplement my food farm income. As you all know very well, it's very difficult to make a living and keep a small farm running with vegetable sales alone. Being able to supplement my income by growing a small amount of cannabis would allow me to continue to expand my food farm, ultimately regenerating soil in the 22 acres that are in Area D, Zone 2. Did I
Thank you
keep
so
it?
much.
Okay, thank you.
Okay, so we will move on now to, we have speed reading. We have correspondence, grant and aid request, electoral area C.
Thank you, Madam Chair. Item C1 is a request for grant and aid, and the recommendation before you is that it be recommended to the board that a grant and aid, Electoral Area C, Cobble Hill, in the amount of $250 be provided to Humanity for Horses Foundation for the rescue of horses that are bound for slaughter, for rehab and rehome if possible.
It's been moved. Is there a seconder? Been moved and seconded. Is there any discussion? All in favor? Any opposed? Motion is carried. Moving on now to information. So number 7, we have area E, D, 2 advisory planning commission minutes.
Thank you, Madam Chair. Item IN1, there are advisory planning commissions from Electoral Area D and E, and those are for information.
So if there's a question on that, we have Director Nicholson.
Yeah, sorry, I forgot to mention this to staff before the meeting, but the minutes for Area E, June 11th, APC are missing page 2.
So they're incomplete and have to come back here again. Thank you for that information. I think staff has that. Director Acton, you had a question?
Yes, thank you. I thought it was interesting how the APC mentioned that they felt they wanted to see more applications, or there was a comment about certain applications. And my APC as well feels that way. So I'm just wondering, are we missing like a happy middle ground here? Or is there an actual document written about what do we send to the APC? There seems to be a lot of unclarity about it. Then there would be less confusion on their part, whether they should be seeing certain applications or not.
Ms. Charoff.
Through the chair, the development procedures and fees bylaw outlines the types of applications that are typically referred to the Advisory Planning Commission. If that's something that the committee would like to address, that strategic planning would be an appropriate time to do that. To add, staff intend to come to the committee soon with a report on development services, and there might be a good opportunity at that time to look more closely at the referral process and opportunities to make amendments to clarify what should or should not go to APCs regularly.
Follow up, Director Acton?
Yes, thank you. That would be great, because what I'm hearing from the APC is that they are hardly seeing any applications, and what I'm hearing from CVRD is they see more applications than they used to in the past. So there's a bit of a disconnect there, so that would be great to hear more about it. Thank you.
Okay, thank you. Seeing no more questions on that, we'll move to R1, report from the Public Safety Division.
Thank you, Madam Chair. Item R1 is a report from the Public Safety Division regarding a budget amendment for fire protection Honeymoon Bay. And the recommendation before you is that it be recommended to the board that the purchase of a used fire truck for up to $50,000 plus tax be funded from the current year operations, and that be approved.
Thank you so much. Welcome, Mr. DeJong. Would you like to?
Well, if, for those of us that have read the report, it's pretty self-explanatory. I'd move the recommendation.
Been moved by Director Morrison, second by Director Acton. Are there any other questions? Director Nicholson.
Yeah, I had a question for staff. It looks like this is a good win for both fire departments, but I'm wondering if you looked around for other, what else was available in the market?
Mr. DeJong.
Yes, thank you. We have, there was a current opportunity that we've been planning on for a year that disappeared. When this opportunity came about, we did look at comparables, and to be safe, there isn't comparables at these benefits for this truck. So,
Seeing no other questions, I will call it. All in favor? Any opposed? Motion is carried. Thank you very much. And that will go to which board? Okay, thank you. Moving on now to R2, report from the Water Management.
Thank you, Madam Chair. Item R2 is the report from the Water Management Division regarding the Stocking Lake Dam and an interim management and co-licensees agreement. And the recommendation before you is that it be recommended to the board that the interim management and co-licensees agreement between the Cowichan Valley Regional District and the town of Ladysmith for the Stocking Lake Dam, describing the interests in the lands, responsibilities, and cost sharing be approved.
Been moved, seconded. Any questions on this? Director Smith.
Through the chair to staff, I just want to make sure and clarify that this agreement will not change any of the current storage licenses on Stocking Lake or any of the current distribution licenses on Stocking Lake.
Welcome, Mr. Dennison.
Thank you, Madam Chair. No, it does not change any of those. We wouldn't be able to change that unilaterally anyway, because that would have to be done by the province. But it doesn't, there's no intent in the agreement to change those.
Is there a follow-up, Director Smith?
No, I'm good.
Okay, great. I'm going to call the question. All in favor? Any opposed? Motion is carried. That will go to the October 9th board. R3.
Thank you, Madam Chair. Item R3 is a report from the Water Management Division regarding Community Emergency Preparedness Fund. And the recommendation before you is that it be recommended to the board that an individual application for grant funding be submitted in conjunction with the town of Ladysmith's application through the CEPF Structural Mitigation Substream for priority-owned and operated Stocking Lake Dam Rehabilitation or Replacement Project, and that's in Electoral Area G.
It's been moved, seconded. Any discussion on that? Director Smith.
Through the chair to staff, it's good to see Brian up and down there. So Brian, I just have a question regarding this. Does this mean that the CVRD staff will be doing the work, or is it the town of Ladysmith staff that will be doing the work?
So the applications for funding for the work to be done, I think probably we would see, likely because we've been doing the work already on the dam stuff, that we would carry on with that because we've already got the background to it and have done the flood inundation and all those kinds of pieces of work already. So I believe the intent, it doesn't, each side has its funding though, so that's not implicit in the application, but that would be the intent at this time.
Thank you. I'll call the question. All in favor? Any opposed? Motion is carried. Moving on now to R4.
Thank you, Madam Chair. Item R4 is the report from Development Services Division regarding the policy for consideration of cannabis production facilities. And the recommendation before you is that it be recommended to the board that the cannabis production land use application policy be approved. And number 2, that staff bring forward a future report regarding the current status of cannabis production facilities in the agricultural land reserve and consider options regarding the regulation of cannabis production and related uses on agricultural land reserve land.
Thank you. Welcome, Ms. Wright.
Good afternoon. So I'm here this afternoon to present a draft policy which includes criteria for evaluating cannabis production facility applications. So just like my previous presentation, I just want to go over the previous action taken by the board. So in May 2018, and in anticipation of the legalization of cannabis, the board adopted zoning bylaw amendments to include cannabis-related definitions, permitted zones for cannabis retail stores, and permitted cannabis production facilities in some zones. So the table here shows that in the orange column is what happened, what's pending approval from the last EASC meeting, for the retail cannabis zones or retail zones. The blue is where cannabis production and cannabis retail is currently permitted, that was decided upon in 2018. And the purple is also where cannabis production is already permitted, and what we will be talking about this afternoon. Also, I just wanted to point out at the start here that the purple, we are not planning on, at this point, adding any more zones for cannabis production. So it's really the purple column that is remaining and that we're going to be talking about. So in terms of cannabis production facilities, they're regulated and licensed by Health Canada, which has established 8 different license classes. Local governments retain the authority to regulate land use regarding cannabis production facilities. So the growing of cannabis, the cultivation, is a separate license from the refinement of cannabis into usable products, which is the processing. So, and there's differentiations between the scale of operations. So licenses are available for micro, small scale, and standard, larger scale cultivation and processing. For cultivation, the difference in scale is determined through the canopy space, which we'll be talking about in a few slides, which is the total area within a facility that's devoted to the growing of cannabis plants. And this also includes if the plants are stacked on top of each other, the vertical height also counts towards the canopy space. For processing, the difference in scale is measured by per weight of the cannabis produced. Only businesses with cannabis processing licenses for both micro and standard are permitted to sell their products to the province, which means that cultivators must sell their cannabis to a licensed processor in order to obtain a license. There are different licenses for growing starter materials, so that would be in a nursery, and for analytical testing and research. Some license types can be combined with other license types at the same site, so you can do, for instance, micro-cultivation as well as micro-processing. Health Canada does not dictate a minimum or maximum building size for cannabis production facilities. So the process with Health Canada, which the local governments are not included on, but I just wanted to touch on quickly. So for an applicant to obtain a cannabis production license, they must use the Health Canada's Cannabis Tracking and Licensing System. This is a rigorous process that takes into account all individuals involved in the proposed cannabis operation, from the directors to the growers, and there are pretty stringent security screenings that happen. I want to note off the bat that the images I'm showing are not applications to the CBRD. They're merely examples for this slide. So applicants are asked through Health Canada's portal to submit a site survey, aerial view, and site plan showing where each of the activities will be taking place. Security requirements vary for each application type, and requirements are much more restrictive for standard or larger facilities than for micro operations. Health Canada may refuse to issue a license if the proposed facility is deemed to be a risk to the public health or safety, if there's false or misleading information in the application, if the security clearance is refused or canceled, or if a refusal is deemed to be in the public interest. And as I stated a few weeks ago, in May 2019, all applicants seeking a federal license must now have a fully built facility that meets the requirements of the cannabis regulations at the time of application prior to submitting their application to Health Canada. So in terms of cannabis micro-production facilities, the micro licenses are intended to make obtaining licenses more accessible for smaller craft growers. So the plant surface area cannot exceed 200 square meters, which is 2,152 square feet. So whereas standard licenses allow for much larger production areas. So in terms of this image this, for you hockey lovers out there, this this shows 200 square meters in relation to compared to a hockey rink. However, this 200 square meters in this instance only takes into account if you're growing on tables, not the vertical. So there's less stringent security requirements for microcannabis, including lower security monitoring of cannabis storage areas. Micro facilities support local, smaller, and craft businesses, where standard facilities have much higher barriers to entry. If the CBRD wishes to permit micro-cultivation licenses outside of the zones which already permit cannabis production, so that purple column from the first slide, micro-cannabis production facility should be defined and the use added to specific zones in the applicable zoning bylaws. So in terms of the definition for cannabis production facility, in 2018, the CBRD adopted changes to include cannabis-related definitions and permitted zones for cannabis production facilities, which differentiated between medical and non-medical cannabis production. Now with the updated federal requirements, medical and non-medical cannabis production facilities are now indistinguishable from a federal licensing perspective, and there's no need to distinguish between the two activities in the zoning bylaw. So it's recommended that the definitions of cannabis production, commercial medical, and cannabis production, commercial non-medical, be replaced with the generic term cannabis production facility. And the proposed updated definition will incorporate cannabis micro-production as well in order to permit micro-production facilities wherever production facilities are currently permitted. So this slide shows, just on a map view, what was adopted in 2018. And where cannabis production facilities are currently permitted. So the applicant's notification requirements. So all applicants for licenses to cultivate and process cannabis must provide written notice to the local government. They also must provide written notice to the RCMP and fire departments. And it's the applicant's responsibility to ensure land use compliance. So to see if the zoning correlates to their site. Their written notice must include the name of the applicant, the expected date the applicant will submit their full package to Health Canada, the class and subclass of the license that's being sought, and the site address. Notification to a local government is not required for analytical testing, research, and sale of cannabis for medical purposes without a possession license. Public notification and consultation are not required, nor is a positive response from a local government. Health Canada does not invite input from local governments on federal license applications, and the notification provides the opportunity to merely express any concerns with the proposed operation to the applicant. So for instance, something to do like a comfort letter or a letter saying if to comment whether it's in zoning compliance or not. In terms of land use considerations, so local governments are able to regulate the location and density of cannabis production facilities outside of the ALR. So in May 2018, the Agricultural Land Commission clarified that all forms of cannabis production in the ALR are considered a farm use, including cannabis grown inside buildings with concrete and other non-soil-based floors. This is updated from their previous regulations, which limited cannabis production to being grown only outdoors outdoors in a field or in a structure that's entirely has an entirely soil base, or in a pre-existing structure or one under construction for the purpose of crop production. Previously, if any proposed cannabis production did not meet these conditions required a non-farm use application through the Agricultural Land Commission. So given these recent amendments, the board may wish to request a report to consider the options to regulate cannabis production and related uses on ALR land. So in terms of the policy, so the policy applies to applications which propose to rezone a parcel to permit cannabis production facilities. It's not currently zoned for the use. So they would go through the rezoning process, which would also include a public hearing. So the procedure would be the same as the majority of, or as rezoning applications. So they would, an applicant would come in for a pre-application meeting. They would submit details regarding the location, size, and design and detailed description of the proposed facility, including the proposed hours of operation and number of people employed, a copy of the Health Canada Cannabis Production License application, and a reason we would ask for a copy is that we would like to see the intent. So the intent behind it is that the applicant is showing how much work they've put in. They have the site plans, they have the aerial plans, they have the floor plans, and they show their complete application, what they're going to provide to the Health Canada. We would ask for details of the number of properties with existing licensed cannabis production facilities in the area, socioeconomic details to support the cannabis production facility, community impact statement, confirmation of adequate water supply, confirmation of adequate sewer and waste disposal, odor abatement plan, security and public safety plan, and the lighting plan. And in terms of the location, we would propose that only one cannabis production facility be permitted per lot. We would propose that cannabis production facilities are not located on a lot with an existing cannabis retail store. This also goes in correlation with how in 2018 the CVRD board adopted the zones zones for cannabis retail as well as production. And a lot of these zones are the same thing. So on an industrial property that's already zoned for cannabis production, you could potentially have a retail store unless this provision was in place, unless the board wishes otherwise. We'd also recommend 300 meters from public independent schools, playgrounds, daycares, sport fields, community centers, and areas where children and youth frequent. This 300 meters is the same buffer that is pending approval by the board for cannabis retail stores. As well as 300 meters from residential or rural residential zones, park, institutional, and water zones, or a comprehensive development or mixed-use zone. Areas, in terms of rezoning, areas designated residential in the OCP and residential zones will not be considered. And if the facility is on ALR land, although we cannot prohibit it, we would require that the facility is located at least 300 meters from all lot lines and water courses. Oh, 30, sorry. The final recommendation is that the cannabis production land use application policy be approved and that we bring forward a future report regarding the status of cannabis production facilities in the ALR and to consider options to regulate the production facilities on ALR land. Thank you.
Thank you so much, Ms. Wright. I have Director Wilson. Oh. It hasn't been moved or seconded. We'll just have a discussion first. You need it moved and you need it on the table. Okay. So is there a mover or a seconder for the resolution? Moved and seconded. Okay. Now, go ahead, Director Wilson.
Thank you, Madam Chair.
It's my cold.
One of the things that comes up over and over again, and we have a non-ALR production facility in my area where I live, very close to our houses. But this is purely on ALR land that we're talking about. The odor abatement plans, what does that actually entail? Is there a stipulation that they will have carbon filters or any kind of really state-of-the-art filters to cut down on the odor? Because that's the biggest complaint we have right now.
So in terms of ALR land, we wouldn't even see the applications for a production facility. They would merely submit a letter that they are putting one in place. However, for odor abatement plans, I'm not quite sure on the specifics of what's required from Health Canada.
Director Nicholson?
I have several questions, but just to follow up on that, on the ALR land ones, we had a application not that long ago for a large facility on ALR land, an indoor cement facility. So would we not have any ability to say, no, we said no to that as a non-farm use? Because it would take so much land out of the ALR?
I'm not quite sure about the specific app. Oh,
I have Mr. Tippett who'd like to chime in on that. Mr. Tippett.
Thank you, Madam Chair. Yeah, if Rosedale Road application is the one you're referring to, Director Nixon? Oh, a different one? Oh, sorry. Okay, never mind. I was going to say Rosedale was not in the ALR.
Ms. Wright, do you have?
So for any application today on, the ALC recently made these amendments. I think it was in May of this year. So if this application were to come forward again, we would have no ability. We wouldn't even see the application. It would go to Health Canada and they would send us a letter. Unless we have a policy in place, a different one.
Okay, well, we better get a policy in place.
That's in the recommendation.
I have a few other questions. May I go ahead?
Follow up? Go ahead.
So I am quite sensitive to the comments raised by some of the people at the beginning about the microcultivation and the importance that could be the craft business on farmland. And I think that's really important. I am wondering whether we should be separating micro and standard in our definitions.
Ms. Wright?
So in the report, I did mention that if we would like to allow micro cannabis in areas that were different than what cannabis production facilities are already permitted on, we could introduce a micro cannabis definition as well as more zones to allow it in specifically, which would not allow standard or larger scale production centers.
So I'm just wondering if it would be practical to do that, because I suspect we'll get a lot of those kind of applications, and we may need to think about them differently. The other question I have is the difference between we've lumped production to include both growing and processing. Is that correct? And I'm wondering if those two things should be separated, because I'm wondering if there are places that we might consider processing, not cultivation. Yeah.
Ms. Wright?
I do understand what you're saying. The policy was really, I looked into a lot of different municipalities and the majority do not separate them. I think I found one that does. And I think the reasoning is the policy would generally be the same except for the zone. So how the policy could stipulate, cannabis production permitted here and cannabis cultivation permitted at different. However, the majority of policies that I've researched keep it as one.
Follow up?
Well, I don't know much about this, but I'm just assuming that there's different energy requirements for production versus processing, different water requirements, different fire hazard risks, and all those kind of things may be different for those two steps of the process. So your decision-making on a land use perspective would be different for the two things. So lumping them together might send us down a road where we just use these blanket criteria without thinking about what is actually happening, and whether it would be better just to be really clear about what we're talking about. I don't know.
Can I comment on that?
Yes, please.
So, Anne, would you like to comment? No? Okay. Sure. So, as it stands, the only way that this policy comes into practice is if an applicant is coming in to rezone as it is. So we could have, if it were separated, it would be a policy for cannabis production as well as cannabis cultivation, and we'd have two separate policies. However, if they're coming in to rezone, we do ask for confirmation of water, sewer, as we would any rezoning. Anne, is there anything you'd like to add to that?
Well, through the chair, so I think that the policy is intended to provide sort of a general list of the types of information that we want to see accompany the proposal. And regardless of the type of application, they would need to demonstrate that they've got adequate water supply or sewage or waste disposal facilities relative to the facility that they're applying for. So I think that there's enough discretion built into the policy to apply to both situations.
Thank you. Director Acton and Director Morrison.
Thank you, Madam Chair. I have a couple questions, but this one, I'm wondering, when you were talking about it would also trigger a public hearing, I think this request kind of came out of, we didn't want this to become a political issue, so please give us some guidelines that we're always going to follow. So adding, is it redundant to add something about the public hearing would be waived in the case of, you know, all the stipulations being met or something to that effect, so that we don't get it decided at the board level whether a public hearing, you know, whether staff wants to recommend or not, just to take that political side out.
Ms. Cheryl?
So the board, when deciding whether or not to waive a public hearing, needs to be assessing the particular application in front of it and determining whether or not that particular application is consistent with the official community plan, and waiving the public hearing is warranted. I don't think you can pre-waive a public hearing.
Follow up, Director
Sure,
Acton?
I just picture a lot of applications coming forward and a whole bunch of public hearings that maybe won't be necessary, but sure, we'll play it as it goes.
Okay, Director Morrison.
Thank you, Madam Chair. And I'm really pleased with the nature of the report, and it was very clear and a fair bit of reading. So through you to our staff, there were some recommended amendments suggested that were presented during the public input period, and I'm a couple of points, I guess, and that I'm comfortable with what staff have presented, and I know that the community and producers have been very patient while we've been finding our way through this. I don't want perfect to be the enemy of good here, and would ask if the approval and recommendation of this to the board to move forward, would that in any way prohibit us from taking into account some of the recommendations, that perhaps the ones that were submitted today? I know, note in number 2 that you're looking at bringing forward recommendations on ALR if we approve this. So can we move forward with what we have here and still then take into account suggestions and recommendations from the public?
Ms. Cheroff.
Thank you, Madam Chair. I think the answer to that question is yes, and staff do already have direction to prepare draft amendment bylaws for cannabis, retail cannabis, and then for cannabis-related definitions. So these types of things can be incorporated into those considerations. And I wanted to add to my last comment that some of the issues around consideration of location at the board level may be alleviated by pre-zoning specific lands to allow for different types of facilities.
Director Acton.
Thank you, Madam Chair. This is perhaps just a request from staff, so it would be like number 3, maybe if it's the will of the committee. But in Area B, and probably in many people's areas, we're still have the old issue of the grow-ops in residential areas, and I still get complaints. And I think it's really disheartening how the message that I'm hearing is that we're just kind of washing our hands of those. Too bad, you know, we didn't have this zoning bylaw in place when that occurred and they had the license. But I would really like to see some way that we can look at accommodating some of these people, or, you know, we are in the business of zoning, we are in the business of land use, and we are also in the people business, so it'd be nice to be able to help some of these people if we can, and if we've created these other zones where it's supposed to happen. For example, we've had to on other pieces of land, we've had to prove that land use wasn't allowed, and so we may be in the same situation. to prove that. But I don't like the idea that we've just washed our hands of it. So is this an appropriate time to ask staff to also bring back a future report regarding the status of these old grow-ups and what we can do for them?
Anybody want to take this one? Not really sure. Mr. Tippett?
Thank you, Madam Chair. I'll take a shot at it anyway. I think, I mean, we could certainly report back. I think the general message that will be in a report concerning the older medical marijuana, as it was called at the time, licenses that the federal government issued, is those were pursuant to a Charter of Rights challenge, and the licenses were issued under the MMPR or MMAR or ACMPR, which are the old federal regulations, and apparently those licenses still persist and continue to be honored, I guess, by the federal government. And so that being the case, we never were involved in any capacity with respect to the decisions about where those uses would be approved. And our hope was that, with this new licensing regime under the Cannabis Act, that eventually those would be phased out. However, if the committee would appreciate receiving a report to sort of get a bit more into depth on that, we could certainly do that.
Well, maybe we'll finish with this one, and we'll welcome that one as well. Director Nichols, Director Haim.
Thank you. Just a question through you to staff, just with regards to the fact that a number of speakers spoke with regards to small craft farmers and micro cultivation. Have you ever come across, recognizing it's relatively new in this sort of thing, cases where there's separate consideration of policies for micro cultivation versus kind of more of an industrial production?
So through the research I did, the majority of the policies might, have a line or maybe a section. However, it would be the same policy that would encompass both larger production as well as micro production.
Okay, I think we are, Director Nicholson.
Hi, thank you. I'd like to, what do you do when you make?
Would you like, you have an amendment to this?
I need amendment, that's the word I need. I would like to amend it so that the micro cultivation is handled, separately, and that that one of the changes be that you are able to do farm sales. Because I think the whole point of this craft industry is to be like the wineries, to be able to provide that. So I'd like to make that amendment.
Could you, your amendment was not clear to me. Could you write that down, or could you repeat that for staff? Because I'm not sure we're going to.
I'd like to, I have to look at the first motion, I guess, don't I?
Director Morrison?
Point of order. I understand the intent and would support what Director Nicholson is saying, but almost as Director Acton's, I think it's a separate motion.
Okay.
I would be supportive of that. I think this needs to go forward, and a separate motion to do that would be more than appropriate, and I would support that.
Director Nicholson, is that all right?
Sure, that's fine.
Okay, so I'm going to call the question on the current recommendations that's in front of us now. All in favor? Any opposed? Motion is carried. I do have something from Director Acton. It could be connected to, okay.
I'm ready.
Director Acton, you have a recommendation?
I do. I would like to move that staff bring forward a further report regarding current status of cannabis production in residential areas with a medical license from Health Canada. So moved.
That's been moved. Seconded. Any question on that recommendation? Seeing none, I'm going to call the question. All in favor? Any opposed? Motion is carried. Director Nicholson, do you have?
Well, I would like to I would like to move that staff prepare a policy for craft cannabis production. That includes the ability to have retail sales on farm.
Okay, that's been moved. Is there a seconder for that? It's been moved and seconded. Is there any discussion on that? You can turn your microphone off, Director Nicholson, if you're finished. So we have that recommendation. Thank you. Director Morrison?
Just clarification that if this is supported, this report will come back to this committee. Thank you.
Director Salmon?
Yeah, just to clarify, will this be redundant at all from what Director Morrison asked, whether we're incorporating the earlier things which were about farm gate was part of that? Do we need a third report?
Director Nicholson?
I think overall it would be better to separate the two because that only applies to ALR, and it may be that we want to have craft facilities in other zones like A2, which is agriculture, not in ALR. So I think it would be worth having it done separately.
Follow up,
From the
Director
beginning.
Salmon?
I think I follow, although I think what you had asked earlier was whether the first part of this, the policy would incorporate some of the public concerns that were raised at the input period. So
Director Morrison?
I was more inclined to suggest that this move forward and the public comments be incorporated into subsequent reports and information brought forward to us.
Okay, I'm going to call the question. Do we need to read it out? Is everybody okay? All in favor? Any opposed? Motion is carried. Moving on now to R5.
Thank you, Madam Chair. Item R5 is a report from the Inspection and Enforcement Division regarding Type C soil deposit bylaw applications, and this report is for information.
Welcome, Mr. McDonald.
Thank you, Madam Chair. Just want to do a quick refresher here as we do have the next 4 will-be applications. Just in the information report, I just wanted to know that Type Cs, again, were defined as more than 1,000 cubic meters deposited in a calendar year on a specific site. Detailed report as attachment.
Could just hold it for a second? There's a lot of chatter in the background. Yeah, maybe we'll just hold while there's people moving and talking in the back. So just a 2-minute break here. People are leaving and chatting in the hallway, and it's interrupting your presentation. Okay, go ahead.
We'll
Thank
carry
you.
on. So soil deposit bylaw number 4236 requires all Type C permit applications to be approved by the board. As detailed in attachment A, was quite an extensive list of requirements, and this includes reports from professionals. These include a valid survey, soil assessment and deposit plan, an environmental protection plan, and a site remediation plan. Staff has done a thorough review of all these reports that have come in for the following applications, and we're quite confident that all criteria have been met. All applications for these sites are for existing sites, and the existing sites were continually monitored to stay within the guidelines of our soil bylaw. I just thought I would answer any general questions at this point, and maybe we can save the specific questions to specific sites after.
Okay. Director Nicholson.
So I'm obviously really curious about how we're handling this in terms of contaminated sites.
Mr. McDonald.
Through you, Madam Chair. The bylaw has no provision of existing sites. It only goes forward. It doesn't look backwards. There is no provision in it to ask for remediation in an existing site, nor does it ask for testing of existing sites.
Follow up, Director Nicholson?
So it doesn't ask for testing, but should it? I mean, could it? I mean,
It doesn't.
Did we miss something that we should be doing?
Through you, Madam Chair.
Yes.
Through direction of the board, right now, as it was written and approved by the board, it was just written to go forward, not backwards.
Well, it seems like we have a problem.
There's placements of soil. I have just, you have a follow-up? Okay, well, I'm going to go to Director Salmon, Director Morrison, then back to you, Director Nicholson. Director Salmon.
Yeah, thank you. Following that, thinking just, could it have a provision moving forward for example, for a monitoring well to be drilled to get a baseline before a permit is issued, so we know future changes?
Through you, Madam Chair, the bylaw can be amended at any time and then approved again by the board.
Okay. Director Morrison.
Thank you, Madam Chair, and might need to go through to staff on this one, and I kind of thought we might be considering some of this, and just reflecting back on the very lengthy process that this organization went through to get this bylaw approved. It's my recollection, and I might look to Mr. Crothers or some of the other senior staff, that we had to very carefully word this this approach in this bylaw to ensure that there would be provincial approval of this because of the provincial government's role in contaminated sites. So I just, perhaps we could be reminded that from staff if it was almost instruction from the province to steer clear of contaminated sites issues and to, as Mr. McDonald said, move forward, or the likelihood of approval of this bylaw would have been far less. Is that a fair assessment of
Staff.
the process?
Mr. Tippett.
Thank you, Madam Chair. Yes, I think that's a fair statement. Certainly the feedback we got during the process is that nothing in our bylaw can speak to the quality of soil being moved under the bylaw. The soil quality issues dealt with by different provincial legislation. The other thing I would note is, and I think this speaks to the point that was made in the public comment section, it's notable that the province requires for local government planning processes site profiles to be submitted in two cases only, for rezoning and for development permits, not for soil deposit permits. To me, that's a flaw. I mean, just based on what I heard today, the province probably should be requiring site profiles to be submitted by applicants to receive soil deposits on their site, and that would go to the Ministry of Environment Contaminated Sites Registry in Surrey, and they take a look at it and would go through a process just like we do on a rezoning. So anyway, that's just my own thoughts here. It's I hope that helps a bit.
Okay. I have Director Nicholson.
Do we require a bond or something to ensure that revegetation occurs and that the revegetation of plans appropriate and that it'll be more than just grasses?
Yes.
Mr. McDonald.
We require a $20,000 per hectare security deposit from all sites, and that's a minimum $20,000. Larger sites, it's $20,000 for every additional hectare of their application.
Director Wilson.
Thank you, Madam Chair. Just as a point of clarification from what Mr. Tippett just said there, if I'm understanding this correctly, the province doesn't require a soil profile for any soil deposit site. Is that correct?
Madam
Mr.
Chair?
Tippett.
Yes, that is correct. I just pointed that out because there is a fairly well-established process for development permits and for rezonings where the contaminated sites regulation requires local governments to have the owners of the site fill out a form that indicates whether certain land uses that could have given rise to contamination have ever occurred there, which would probably include the deposit of potentially contaminated soils. And if any one of those questions is answered, yes, it goes off to Surrey. Surrey looks at it at the Ministry of Environment Contaminated Site Registry and then directs further work to be done before, in the case of development permits or rezoning, land use changes can occur. And the fact that they haven't done it in this case is interesting, and to me, again, looks like a gap. Like we can't, on our own accord, require that because it's outside of our jurisdiction. It's something that would be nice to do and probably would make sense to do. Well, would make sense to do.
Yeah, follow up, please.
Follow up, Director.
Yeah, and this is why I'm very concerned about this, because it's almost like a directive from high up that basically says thou shalt obey whatever we say, and we have no say in the matter at all, and that's why we're in the situation that we are right now. Just as an observation, I would love to see some kind of movement with giving us, as a board, some kind of power or direction to be able to say, we will do this and we will do that. But it's just an observation on my part.
Okay, this is for information. Director Nicholson.
I guess I'm still really not clear on why if we're issuing a permit to deposit soil, why we can't require that the site be verified that it's clean before the soil is deposited. Because it just makes no sense depositing it on top of contamination. It's just crazy. So I really don't understand why we couldn't, as part of our process, require that.
Can I refer that to, I think Mike has the answer to that one. I think Mike has already touched on that.
Yeah.
Oh dear, Madam Chair, I was speaking with the General Manager.
Yes,
Could you
I'm sorry,
rephrase the question?
I see that. Can you repeat it, Director Nicholson?
Mr. Tippett.
Thank you.
I am not convinced that, I don't understand why it is that if we have a soil deposit bylaw moving forward, that when someone comes and requests to be able to deposit soil, we cannot say, yes, as part of the process, you have to show to us that the site that you're depositing it on is clean.
Madam Chair, yeah, the bylaw doesn't currently say that, and the appropriate way for that to occur would be for the province to require site profiles to be submitted. But that's not to say there isn't something we could possibly do in terms of amending our own bylaw to simulate, let's say, the effects of what it would be the case if the site profiles were triggered. But that, at the present time, doesn't exist in the bylaw. The only reference to site profiles in the bylaw right now, as I understand it, and that's what my little conversation with the General Manager was about, is site profiles regarding the site from which the soil to be deposited to the site is coming from, as opposed to the site that it's going to be deposited on.
Director Nicholson.
So what do we need to do to get this fixed starting now?
Madam Chair, I'm not really an expert on the content of this bylaw. I think Ian knows more about it than I, but I think what I can say is that we could go back and do further research on this and see what could possibly be done that wouldn't run afoul of senior government's authorities in respect of contaminated sites, and report back to the committee on that.
Does that need to be a resolution or just something you've heard from the committee? Okay, good. Okay, thank you so much. Moving on now to R6. Welcome, Mr. Warwick.
Thank you, Madam Chair. Item R6 is a report from Inspection and Enforcement Division regarding soil deposit permit application for PID 009369635. And the recommendation before you is that it be recommended to the board that SDC-19-03 for PID 009389835 South Shawnigan Lake Road be approved.
Thank you. Welcome.
Thank you. So this site is one of the ones, the four that we have up today, that has completed applications. The staff has viewed the application. It appears everything is in order. I have personally monitored this site since the start of the bylaw, and I don't see any issues forward. I've got some slides here showing some pictures on how they are complying with the bylaw. So this site, as you enter, you can see it has a paved apron and water truck station, which keeps dust and dirt from entering the road. Every time I've entered, it's it's a very clean site. I don't see any issues in that respect. It's hard to see in the picture, but there is a gate across the property that they lock during closed hours to prevent unlawful entry and deposit during times outside of the bylaw. In these pictures, it enters into the property. There's a station where the drivers come in and submit their logbook entries to show where this soil's being coming from, and it's there. I've inspected their logbook entries on multiple occasions, and everything seems to be in order in that respect. This is just a general view of what the site looks like. You can see there's the land has been leveled, and the deposits come up, and the trucks dump over the edge, and then it's pushed out to keep it level and compacted. This is one picture showing the live edge, which is where the trucks actually do the dumping, and it continues on as it's pushed down by equipment. The next picture shows a runoff pool, so any water coming from the site will collect in there to reduce sediment going down into the streams. Basically, like I said, we have been monitoring the sites. We've seen the application. It is done by professionals. They've identified that everything is in order, and going forward, they've also supplied that deposit for to confirm remediation is done at the end of the site. So all payments and deposits are in order, up to date.
Thank you. So the recommendation is before us. Is there any questions for staff? Director Nicholson.
So just to be sure, this is not one of the contaminated sites?
So this site, there's no identified contamination on the site. There was not to my knowledge, there's never been an identification of contamination on this site. If you're ones from what you're referring to in the meeting, this is not that site.
Follow-up, Director Nicholson?
And the material that they're dumping is okay? It's not hog fuel or whatever?
This site, all the materials that has arrived on site, they do have soil acceptance agreements from all the companies coming, so to the best of our knowledge, everything is clean. There is no products besides soil that I know of entering this site.
Director Acton. Did you know? Oh, no? Okay. You're the director of the area. I'm looking to,
Okay,
Director Salmon.
I'll move it.
Okay, it's been moved. Is there a seconder? Moved and seconded. Director Salmon, do you have a question?
Yeah, just a question that would apply to all these sites, I think. Just on, I'm sure we have an answer to this, but reliability, if we issue a permit and down the road it turns out that they're in violation of, are we in some way liable for inadequate diligence or any kind of future liability? Maybe a legal question.
Mr. McDonald.
To you, Madam Chair. That'll be a follow-up question for our legal counsel. I'm not aware of what legal recourse there would be against us in that case.
Director Acton.
I'm just curious, what land designation are these sites? They're all F1?
This site in particular is an F1 zone.
It's just kind of disheartening how we treat our forestry lands.
Director Wilson.
Thank you, Madam Chair. It's an interesting point that Director Salmon has just brought up there, and I'm now concerned that if we go ahead and approve this and then we find later on that there is liability on our part, then we could have a real problem. I would prefer to refer this back or delay it sometime until we get a definite answer on this particular subject from our legal people.
Mr. Crothers.
Thank you, Madam Chair. Just seek clarity from Director Salmon with respect to contamination, is what your concern was about liability? Just overall? Overall. I was just going to make the point that we have been prohibited through concurrent authorities to be addressing contamination. And in that regard, the CVRD would assume no liability with respect to contamination because it's clearly outside of our jurisdiction.
Okay, Director Salmon?
Yeah, just to, okay, I know I didn't mean contamination at all. I just meant there's various requirements in the bylaw that it be clean fill and that it not be residential, or I forget the various other things. It can't be hog fuel is one of them, road waste. So should we in future find that, oops, we did, what's our liability? Maybe, how would we get a legal opinion on that?
Yeah, I can't answer that.
Could I move that we do get an answer? Or do I have to move that, or can we just get a report at some future date?
We have the motion on the floor currently, and are you wanting to, Director Acton?
I'm going to support the motion. I think this is why we've created the soil bylaw, is so that we can regulate and we can understand what's happening. So I don't feel comfortable delaying the permit process when somebody, this site actually has been compliant and has been very open and transparent with our bylaw officer. And, you know, if there's other ways that we can avoid soil dumping, I'd like to look at that. But for now, this is what we have, is a soil dumping bylaw, and I would move to move this permit.
You're in support
Thank
of
you.
this one. Director Morrison?
Thank you, Madam Chair. This has been a multi-year project of this board's and of staff's in pursuing a very difficult area. And yes, there's professionals that we're relying on, people with professional designations with stamps that are responsible for ensuring geotechnical, all of those other aspects of this. And I'm uncomfortable with delay when this is the best foot forward we can put on this matter. And I think it's been made very clear that the community wants this, and I support Director Acton's comments, and that further delay isn't appropriate, that we should proceed with the ones that we feel comfortable in approving. Thank you.
Director Wilson and Director Nicholson.
Thank you, Madam Chair. Yeah, it's a good job we're allowed to change our minds at this particular type of meeting, but I do agree with what Director Acton and Director Morrison has said. It's been a proven site that's been well looked after and well policed by all the authorities. The only comment that I would make, that in the future for new sites, perhaps we could get a legal opinion on whether any future liability would come up. But in this particular case, I don't have any problem with supporting the approval.
Director Nicholson.
Thank you. I want to talk about this pasture grass seeding. So this site, what do I know about the long-term reclamation of the site? It's going to be a hayfield? And if forestry land's going to turn into hayfield, or what?
Can I get the owner to speak on the reclamation on it? Sure. Is that all right?
Sure.
This is to do with reclamation
Of this particular
of this
site?
particular site. So is
Yeah.
the applicant here?
Is here.
I'm sorry, what was the question?
Well, I'm wondering, I mean, this used to be forestry land.
Yes.
With trees growing on it, and it seems that we're seeding it to pasture grass. So is the intent to turn this eventually into a hayfield?
No, the long-term goal was actually to establish a type of recycling station or a diversion station. It's a massive piece of property. It's going to take some time to develop. It has been all logged off, so basically a forestry, but it's a stub farm at this particular point. So fill it to make it usable land so it can be used for better purposes in the future. Not necessarily a hayfield, although it is an option.
So in the official community plan, is it identified as,
I couldn't tell you.
okay, well.
Thank you.
Okay, thank you. I'm going to call the question. All in favor? Any opposed? Motion is carried. Thank you very much. We move on to R7.
Thank you, Madam Chair. Item R7 is a report from the Inspection and Enforcement Division regarding soil deposit permit application, PID 029596947, and the recommendation before you is that it be recommended to the board that SDC-19-04 for PID 029596947 Trans-Canada Highway be approved.
Welcome again, Mr. Warwick.
Thank you. Once again, this site, I have been monitoring this site since the start of the bylaw. I've had no issues, I've had no complaints come up on this site, and is adhering to all the requirements of the bylaw. In this one, once again, I have a slide showing some of the information on it. So we start off showing the paved apron again to keep dust down on the property. It's hard to tell in the picture, but there is a gate on the top of this property as well. Then you come in on the next picture is the wheel wash station, showing that that's once again to keep the dust off the site and mud off the roads. We have a sign-in station here where the trucks will enter their logbook entries to make sure everything is done properly in that respect. Then we have a picture showing the site, and it actually has some grass growing on it as well, as you can see in the picture, from giving you an idea of what was happening on the site before the bylaw was in place. But they were already remediating areas that they did work on with grass. And then it shows roads going down to the areas that are in the current fill stage. These pictures show there's a runoff ditch here and then area for the water to filter the sediment out of it before it enters back into the water courses. This is a picture showing the live edge again, where the soil is being dumped and pushed over, and then this picture showing after it's been compacted and being leveled out. So once again, this site, I have no complaints about this site going forward from the respect to the bylaw, and staff recommends that it's approved for its application as well.
Okay, I look to the director of the area. So moved? Oh, question, go ahead.
Just a question, I don't have any issues with this, but this site has a campground rezoning pending as well. Is there any implications for if we approve a soil permit, future rezonings? Is there any, maybe it's a planning question?
Yeah, I think it sounds like a planning question to me.
Don't quite know Ms. Cheryl?
So through the chair, any future zoning of the site, future OCP designation or zoning would be subject to the discretion of the board, hopefully following a fulsome community consultation process.
Director Nicholson?
So I just want to ask each time, do we have any concerns about contamination at this site?
Once again, this site, the sites get agreements from the trucking companies to say that they're not bringing contaminated soil. I have seen nothing on the site that I would suspect is contaminated soil.
And we're sure that they're not dumping hog fuel?
I have never seen any hog fuel on this site.
Oh, so it's been moved and seconded?
Moved.
Okay, all in favor? Any opposed? Motion is carried. Moving on now to R8.
Thank you, Madam Chair.
Oh, can I just, excuse me, I was just handed R17. The proponent needs to leave, so maybe we could move that up. Was that the question? Director Wilson?
Yeah, Madam Chair, if there's no objection from the board, it should be a fairly quick one for R17. The proponents are here and they have ferry and family commitments on the mainland that if we could perhaps bring this forward.
We can accommodate that. So
Thank
we'll
you.
move to R17. Sorry, Mr. Warwick, just to...
Thank you, Madam Chair. Item R17 is a report from the Development Services Division regarding application number DP 19A05 for the Malahat Skywalk. And the recommendation is that it be recommended to the board that issuance of development permit application number DP 19A05 Malahat Skywalk be approved, subject to adoption of the zoning amendment bylaw number 4287 and number 2, that the general manager of land use services be authorized to permit minor revisions to the development permit DP 19A05 in accordance with the intent of the development permit guidelines of South Cowichan Official Community Plan Bylaw number 3510.
Thank you. You're moving that? It's been moved? Is there a seconder? Moved and seconded. Is there any other questions for staff on this? Do you need a presentation or anything? Any questions for Mr. Tippett or the applicant? I'm going to call the question. All in favor? Any opposed? Motion is carried, and that goes to the October 9th board. Moving back to R8.
Thank you, Madam Chair. Item R8 is a report from the Inspection and Enforcement Division regarding soil deposit permit application PID 009377-123, and the recommendation is that it be recommended to the board that SDC-19-06 for PID 009377-123 Goldstream Heights Drive be approved.
Okay. Director Acton.
Thank you, Madam Chair. So I won't say the C word that ends with taminated, but this did not get a clean bill of health in 2012, and this is right beside, we saw a woman here, she was in tears, her well is highly contaminated. We're not saying where it's coming from, but what I would really like for this to go back with staff and work with the applicant, work with Mrs. Brennan, and see what we can do. We're in the business, I've already said, we're in the business of helping our people, and this is our opportunity here to do that. And
You referring this back to staff?
I would like to refer this back and have
Is there a seconder on the referral?
them work together.
It's been moved and seconded. Is on the referral. Any discussion on the referral? Yes, Director Acton.
Does staff need any direction on this then?
Yeah. Yes, okay. So I'm gonna, just a second. Referring it back for what, Director Acton?
Well,
Just need to be clear on our referral so that staff understand why we're
concerns.
referring it back.
So it has been designated by the Ministry of Environment, so I'd like staff to work with the ministry and understand where we stand with that and where they stand and what their commitment is. I understand that there were some reports requested that were never completed on either from the ministry or the applicant. So I'd like for those conversations to happen with us being the lead on this, and for the neighboring property to be looked at. If we look at our application process, there's a clause in here about being 100 meters away from an aquifer, groundwater impact assessment. So I think there's more that needs to be done on this file. And so I would like to see that happen for groundwater
It's
protection
been moved
and
and
that well.
seconded for the referral. Is there any more discussion on that? I'm gonna call the question on the there's Director Salmon.
Do you want to add the hog fuel to that? So we look at I visited the site, or overlooked the site recently, there's vast amounts of hog fuel.
Well, I
there.
think that would be part of the, in the referral for staff to be looking at it. I'm not sure if we're gonna get specific into each and every.
She was, so.
Okay, I'm gonna call the question.
Sure, staff can explain the hog fuel. Apparently there's an explanation for that. But that can come back.
Okay, on the referral. All in favor? Any opposed? Motion is carried. Moving on to R9.
Thank you, Madam Chair. Excuse me. Item R9 is a report from the Inspection and Enforcement Division regarding soil deposit permit application for PID 027814382. And the recommendation is that it be recommended to the board that SDC-19-10 for PID 027514382 Shawnigan Lake Road be approved.
Director Acton.
So this is another site that was also flagged by the Ministry of Environment in 2012 with such things as lead and polyaromatic hydrocarbons. Again, my request would be to go back and see if the ministry had followed up on their side of they were required to do more reporting and if that ever happened.
Director Morrison.
Being mindful of our responsibilities, I'd refer this to staff for clarification of possible deficiencies and report back to committee at its soonest possible convenience.
Thank you so much. That's much clearer resolution. Thank you. Referral. It's been moved and seconded, Director Acton and Director Morrison, with a clearer referral for staff. Is there any more questions on that referral? On the referral? Seeing none, all in favor? Any opposed? Motion is carried. Moving on now to R10.
Thank you, Madam Chair. Item R10 is a report from the Development Services Division regarding application number DP 19B01 for 700 Shawnigan Lake Road, and there is a recommendation that it be recommended to the board that, number one, development permit application number DP 19B01 for PID 030-047-919 be approved, and number two, that the general manager of land use services be authorized to approve minor revisions to permit number DP 19B01 for PID 030-047-911 in accordance with the intent of development permit guidelines of the official community plan bylaw number 3605.
It's been moved and seconded. Is there any discussion on that? Seeing none, I'm going to call the question. All in favor? Any opposed? Motion is carried in a 5-minute recess. Thank you so much. Sort of. Can we welcome everyone back to their seats, please? And directors to their chairs. We really need to, this is still a meeting. When we have the 5-minute break, it's a 5-minute break for the committee and not the interaction for people to come forward. So it really is to stay to our committee meeting, and the 5 minutes is over, and we'll move on now to R11.
Thank you, Madam Chair. Item R11 is a report from the Development Services Division regarding application number DVP 18E03 for 4897 Belvedere Crescent. And the recommendation is that it be recommended to the board that development variance permit DVP 18E03 for 4897 Belvedere Crescent to vary Electoral Area E zoning bylaw number 1840, section 5.2, subsection E, to increase the maximum size of an accessory building from 100 meters to 214 meters be approved.
Welcome, Mr. Munn.
Good afternoon, committee chair, committee members, applicant and staff. I'm here to present this development variance permit application. The purpose of the application is to increase the size of the development of the proposed accessory building from the required 100 square meters to 214 square meters. The building is proposed for the north side of a 1.5 meter, north side is at the top of this slide, 5-hectare lots. Previous applications for this type of variance on smaller lots have been supported by staff. There's no specific guiding policy regarding building size. OCP policy 7.5 supports some variance in citing. The Advisory Planning Commission reviewed this application. No objection was entered regarding the size of the building. They recommended a 6-meter rear yard setback, which is beyond the 1.0 meter setback. They also recommended no more accessory buildings and a future review of requirements regarding this issue. No policy or technical reasons exist for supporting limiting the number of accessory buildings to 1 on this site. The applicant has responded by increasing the setback proposed from 1 to 4.5 meters, as shown on the slide here. Staff recommend approval of the application as per the submitted drawings.
Thank you so much. So there is a recommendation. I'm looking to the director of the area. It's been moved. Is there a seconder? It's been moved and seconded. We already read the motion. I'm going to call the question. All in favor? Any opposed? Motion is carried. Thank you so much. That goes to the October 9th board. Moving on now to R12.
Thank you, Madam Chair. Item R12 is a report from the Development Services Division regarding application number DP19A01 for 1080 Shawnigan Mill Bay Road. And the recommendation before you is that it be recommended to the board that development permit application number DP19A01 for PID 006390676 and 009487310 be approved. And number 2, that the general manager of land use services be authorized to permit minor revisions to DP 19A01 for PID 006390676 and 009487310 in accordance with the intent of development permit guidelines of the official community plan bylaw number 3510.
Welcome. It's been moved. It's been moved and seconded. It's been moved and seconded. Do we want to hear the presentation, or we can move with that? You'd like to hear it? I'd like to hear about the water. Okay, so go ahead.
I'm here to present development permit application DP19A01, and I'll just note that the applicant is here if you wish to hear them speak. The purpose of the application is to ensure development permit guidelines are addressed by the applicant before subdivision of the land can occur. 5 sets of development permit guidelines apply. 4 of those are regarding environmental protection. 1 is regarding agricultural protection. There are 4 issues arising from these guidelines. The first one involves invasive species. Excuse me. Prior to final subdivision approval, an invasive species plan may be subject to approval final subdivision. Landscape retention, develop with care. Ministry of Environment recommendations in their guidelines recommend design and enhance the ecosystem features, minimum retention at the perimeter of the site, but not landscape retention on every proposed lot. The benefit involving this application is that the applicant has proposed or agreed to a 5% cash in lieu for park purchase, and as well added at their proposal, park dedication in the form of a park link. Just behind him on my slides here, that's the site. And at the bottom of the slide, you can see a proposed right-of-way labeled park in pink, and that would be the park dedication. It also has a link to the cul-de-sac. The agricultural protection issue involves a minimum 5 meters adjacent Shawnigan Mill Bay Road, and this may not be a viable setback to retain vegetation, as it may be subject to wind and encroachment damage. The fourth issue arising regards landscape and rainwater environmental protections. Guidelines emphasize natural methods, and the submitted plan emphasizes a choice of topsoil replacement. The proposal in general meets the intent of the guidelines to emphasize the preferred choice of landscape retention more than site clearing. Planting suggestions are attached, but the subdivision plan would be the document which shows areas of retention and development.
Any questions for staff? Director Morrison?
Thank you, and I'm not sure whether, I looked in the package, was trying to find the Mill Bay Village Containment Area map. Was there one in our package? I'm just noting that this is, I guess, on the outer edges of that containment area. I think I saw it in written form, but I didn't see a map. Is that the case? Is this actually within and at the edge of the village containment boundary?
Mr. Munn?
Chair, yes, it is. It's within the village containment boundary. It is on the edge. So the part of the boundary would be Shawnigan Mill Bay Road.
Director Acton?
Can you refresh my memory? Was there something about like a well enhancement or the water? So could you talk to that?
Mr. Munn?
Thank you, Chair. Water issue has been raised with this site, and discussions ensued over the past few months. This is a development permit application which does not involve the issues of potable water. That's a subdivision issue for the subdivision application, and has been dealt with separately by both engineering and comments with the Ministry of Environment. So that the issues there involve well on this site and connection to the Kerry water system, and that would come before this committee and the board at a later date when connection is a subject of approval.
So it's in our package, Kerry Village Water. Director Acton, follow up?
Yes, I think this is maybe for management, but the 5% in lieu of parkland, is that designated from the province?
Yes.
Oh, okay, 'cause it's just not enough.
Okay. No, it is not. Okay, Director Nicholson.
Thank you. I was curious about the trails. So I looked at the park's master plan, and the choice has been to provide access to the trail that will eventually go through to the Mill Bay Shopping Center area, I guess, as opposed to along Shawnigan Mill Bay Road, which would take you to closer to the Kerry Park Recreation Center. So I'm wondering how the priority was decided there, and whether that 5%, although it's not much, how we can make sure that it's directed towards improving road safety, because that's a really busy road, and there'll be a fair number of residents now who may have kids who want to walk to the rec center.
Mr. Munn.
Chair. The dedication of park was provided by the proponent after the advisory Park Commission had recommended the 5% option under Section 310 of the Local Government Act. So this is a proposal that's part of their proposal and not a requirement. The park, which could contain a trail, would connect Shawnigan Mill Bay Road to lands beyond, including the Stonebridge, proposed Stonebridge development, if you're familiar with that. And the connection would then connect with the proposed trail or pedestrian access along Shawnigan Mill Bay Road to the Carey, in the vicinity of the Carey Park Recreation Center. In regards to the standards for those trails or trail, I'd have to refer to the parks planner.
Follow-up, Director Nicholson?
Not a follow-up, but I'd like to get back to this water question. Are we leaving this issue of water too late in the process? Like, it seems like we're doing an awful lot of getting ready to go without, confidence that we've got water happening in this area.
Ms. Cheroff?
Thank you, Madam Chair. So Development Services is obligated to process the application that's presented to it. And in this case, it was an application for subdivision for 13 lots. And so that's the application that's being reviewed in contrast to the development permit guidelines that we have in place. If for some reason the development cannot connect to community water, and the development permit in that case would need to be modified, or a new development permit application would need to be applied for. So while the issue of water is important, it can't be considered in the context of this particular application.
Okay, go ahead and call the question. All in favor? Opposed, if any? It's been carried. Move now to R13.
Thank you, Madam Chair. Item R13 is the report from Development Services Division regarding application number ALR 18E01 for 4832 Waters Road. And the recommendation is that it be recommended to the board that application number ALR 18E01 for 4832 Waters Road for subdivision within the Agricultural Land Reserve not be forwarded to the Agricultural Land Commission.
I look to the director of the area. Move the recommendation.
I'd like to move option 2.
Option 2 is in our package. Do you have option 2? Oh, we don't know what, sorry?
Could we hear staff's report?
Yes, we can have the staff report as well. It has not been seconded either.
So the subject property is located in Glenora Deer Home. It's approximately 1.5 kilometers southwest of the Glenora Community Store. The applicant is proposing to subdivide the property into 2 parcels. Each would be approximately 12 hectares in size. The land is designated agricultural and zoned primary agricultural, and the subject property is within the ALR. The objectives and policies of the official community plan call for long-term protection of agricultural land and discourage fragmentation of agricultural lands. Our practice as staff has been to support subdivision applications only when there's a benefit to agriculture. The minimum parcel size for A1 zone is 12 hectares. However, this excludes any wetland or water body areas. Because of the wetland system on the property, the application does not meet the minimum parcel size required for the subdivision. The board's policy regarding ALC applications has been not to forward applications to the ALC where they do not comply with the zoning requirements. Here you can see the property and the wetland system towards the top. We're recommending that the board not forward the application to the ALC. The applicant is in attendance and would like an opportunity to speak.
The applicant would wish to come forward, and if you'd like to add any more information.
Thank you.
Go Can you speak into the microphone, please?
All right, thanks. The main issue seems to be the lot size. Our bylaws, 1210s, says the lot size, minimum lot size shall not apply where the owner agrees to register a covenant restricting construction of the building on the land. We're quite prepared to make a covenant covering that. So I don't think that the minimum size is an issue in this area. Thank you.
Thank you. There is a, yeah. We'll read option 2. I did not have a seconder for option 2, but we will read option 2.
Thank you, Madam Chair. Option 2 is that it be recommended to the board that application number ALR 18E01 for 4832 Waters Road for subdivision within the Agricultural Land Reserve be forwarded to the Agricultural Land Commission.
You could. You've seconded it? Okay, it's been moved and seconded for option 2. And Director Acton?
Yes.
And I'd like to put myself on the list.
I would just.
Oh, and everybody else too.
I respect the director when it of the area when it comes to the agricultural land reserve. She is really aware of all these properties and makes good recommendations. So I'd like to hear her rationale. To put you on the spot, Director Nicholson.
I had her on the speakers list. I'll go ahead with her first. Director Nicholson, Morrison after to follow.
Thank you. This particular site is in Glenora, in the Coxsila watershed, close to Glenora Creek. It is in ALR, but it is forested land. And it is not, this whole area is really challenged agriculturally by water. So if there's going to be any agriculture on this land, it's going to be, you're going to have to build water capture and storage in order to do that, which is becoming more and more the case in the ALR land in the Coxsila watershed. And on top of that, it is not particularly productive agricultural land. It's rather stony. In addition, so my way of thinking is there is no loss to agricultural productivity for this to be divided into 2 lots, really to help the owners who have lived there for 20 years. Then the parents died and there's an estate sale, and so in order to settle the estate with the rest of the family, but it would be nice for them to continue to live on the site. So they want to subdivide it, and there would be 2 12-hectare lots, and if you wanted to do limited small-scale agriculture and create some water storage capability so that you could do that, this does not preclude it, and 12 hectares is quite adequate, even if you take the wetlands out, to do that. I really don't see a downsize from an agricultural perspective for this, and it would definitely help the owners or the applicant move forward with settling the estate. So I would really like to see it move forward to the ALC to see what they decide.
Director Morrison.
Thank you, Madam Chair. I was going to ask a question of staff, but the director has made clarification. This is in regards to state matters in this file. I'm reluctant to support this resolution, and I may actually oppose. This is a circumstance in which our policies are in regards to our staff's best recommendations. When we deal with land use matters, it's land use, not addressing the challenges that the individuals that come to us may face in regards to estate issues or that sort of thing. And it brings to mind the number of times that we have been approached around Cowichan Lake where people have come to us and said, the original family that bought this property have 4 kids and they all want a chunk of Cowichan Lake waterfront, and we should do it just to be fair so that they can settle their estate. Our staff's recommendation, not the one on the floor, is that, and very clear to me, and I believe that staff recommendation is the appropriate one and should be supported, so I will not be supporting this second, the resolution that's on the floor, not the one on the
Yeah.
screen.
I have Director Haim, and then, were you on, Director Haim? Okay, I'm going to put myself on the list and then Director Wilson. I absolutely agree with Director Morrison. We've worked very hard on the protection of the ALR, and we also work very hard in respecting the staff and its land use, not the owners. And even if the soils or the compatibility, there could be other types of things that could be put on the farmland, animals. It just doesn't have to be about growing and grain. So I will be opposed to the option 2 resolution that's on the floor. And I'll move to Director Wilson.
Thank you, Madam Chair. There's a couple of good points here about not particularly growing crops on the agricultural land, and perhaps putting something else there, but reading through the bits and pieces, I don't quite see what else could be put there. It's pretty poor land, it's surrounded by forest and all the rest of it. And this is not a question of prime lakefront property, as has been pointed out, trying to be divided up. That's an entirely different question altogether. This is about a property which really doesn't produce much or could be any good to anyone. So I'm in support of Director Nicholson's proposal.
Seeing no other hands, I'm going to call the question on option 2. All in favor? Opposed, if any?
Please leave your hands up. The motion is carried.
Moving on now to R14.
Thank you, Madam Chair. Item R14 is a report from the Development Services Division regarding application numbers DP 19D15 and DVP 19D01 for 4675 Trans-Canada Highway for PID 001348281. There are 2 options. Staff are recommending option 1.
Okay, welcome.
The subject property is located on the east side of the Trans-Canada Highway, at the south end of the Whipple Tree Junction commercial area. The applicant is for the Pioneer House restaurant, which was closed following a fire in 2018. They're requesting to rebuild an addition that was destroyed by the fire. The addition is within the side setback area, and therefore a development variance permit is required if the addition is to be rebuilt. The addition is also adjacent to agricultural property, and so the Agricultural Protection Development Permit Area guidelines apply. In this case, there's an existing vegetative buffer between the restaurant and the adjacent agricultural property, and we're recommending that a fence be constructed to further protect the agricultural area. The development is commercial, and so a form and character development permit is required to address the addition. The addition has been designed in keeping with the existing log construction and is in a low-profile location at the back of the property. For these reasons, we're recommending that the development permit as well as the development variance permit be approved.
Okay, it's been moved. Is there a seconder? It's been moved and seconded. I call the question. All in favor? Any opposed? Motion is carried. Moving on now to R15.
Thank you, Madam Chair. Item R15 is the staff report from the Development Services Division regarding application numbers DP 18B19 and DVP 18B01 for PID 005997283, development permit application and development variance permit application for Phase 3, Shawnigan Station. And yeah.
She's just reading the recommendation. It doesn't have to be.
Can we have our discussion first?
We'll go ahead with the recommendation and then we can, she was just reading it. Okay, go ahead. Can we hear from staff?
R15.
Okay. Welcome, Ms. Herrera.
Thank you, Madam Chair.
Yes, so this is application DP 18B19 as well as a development variance permit, which is DVP 18B01. So the staff report combines these two applications. The DP application is required due to the South Cowichan Rural Development Permit area and the guidelines that are triggered through the subdivision process. And the DVP application is required when any variance to the zoning bylaw is being requested. So this application is for a 71 lot subdivision, and the proposed variances relate specifically to the RR5 regulations. And the development permit area guideline review was attached to the report and demonstrates that the application meets the intent of the DPA guidelines, the South Cowichan Rural DPA guidelines, and therefore staff is recommending approval of the DP. However, the current subdivision plan will likely need some revision based on the outcome of the variance request. Any revisions would be in keeping with the general subdivision layout and could be addressed prior to having the DP issued. This is the subdivision plan and the layout proposed. The 71 lots are connected to phase 2, and I have just turned this plan and the slide to try and make it stretch out here. The strata roads would connect with phase 2. So the variances that are being proposed, so right now, in terms of minimum parcel size, lots that are between 325 square meters and 460 square meters are limited to a dwelling width of 5 meters. And these regulations are essentially density requirements and are recommended not to be varied and due to the Local Government Act. So staff has recommended denial of that variance request. The second variance relates to a common storage requirement that is listed within the special regulations of this zone, and requires that land be set aside as a common storage area for use of the residents there. And a similar variance was granted previously, although it no longer applies. It was a variance to the mobile home park bylaw at the time. So staff is supporting this variance again, but has recommended conditions similar to the previous previous approved development permit. The conditions are meant to secure what has been offered by the applicant, which is a common area for parking in a small park. Staff has recommended that the area be slightly increased to be the same as what was previously approved through the old DVP, and therefore a draft DP and DVP have been provided in the report, and option 1 is recommended. The applicants are also here, and I believe would like to speak when they have a turn.
Sure, would the applicants wish to add anything? Absolutely. Great, come to the podium, please. Thank you.
Madam Director, I commend you on your efficiency. I spend a lot of time in chambers throughout BC and Alberta, and there's a lot of municipalities can learn from how you.
Oh, your microphone, please. I want to hear that. Everyone wants to hear that.
Oh, you.
Say that again?
I commend you, and I think there are many municipalities across all of Canada that could benefit for how you execute and sever the head for these meetings. Well done.
Thank you so much.
So there's a bit of history I want to add to this. Before this was rezoned as RR5, it was MP1, which was Mobile Home Park 1. And as a requirement in that MP1, because most mobile homes don't come with a parking garage or any storage, that was in that bylaw. And also, to limit the width of a mobile home, if you were less than 460 square meters, you couldn't have a double wide. And so that's originally where it started from. And it manifested itself somehow into RR5. I had conversations with Mr. Tippett. I introduced myself 2 years ago and had an intake meeting with him and all stakeholders within the regional district, and discussed the application before we submitted the application, so that, you know, it's my job as the agent for the ownership group to due diligence, to make recommendations, to make sure that we're adhering to bylaws as we understand them. So at my intake meeting with Mr. Tippett, his own personal belief was that those two requirements were inappropriately carried forward from MP1 and RR5. So that's why when we developed our concept, we believed, and based on the other meetings I had, which included engineering and planning, that this would probably be an acceptable path to move forward. A requirement of 5 meters gives you a 16-foot wide house. Throughout the rest of the regional district and throughout the rest of the province of Alberta, it is common practice to have 5 and 10 as side yard setbacks. Now, there's some other regulations that come into place. You have to have a maximum footprint so that there is still green area that will allow for the reinfiltration of water into the table. You have to make sure that you adhere to fire department and fire regulations, that you don't exceed certain glazing components in your sidewalls. But to have a restriction that a new homeowner, and this whole plan is premised on delivering a product to the first-time homeowner. These are starter homes for that 1.5 children. I haven't figured out how that half a child goes trick-or-treating, but regardless, that's what we have here. This is a starter home subdivision. We know that we've made the improvements to the sewage treatment plant because it's a self-sustaining property. We have our own wastewater treatment plant. We have our own potable water. That's all been executed. The development moved forward. We've spent the money. We've upgraded that. The existing phase 1 and phase 2, people that reside there now will benefit from this because their strata fees are going to drop significantly. And in the phase 1 and phase 2, all of those homes adhere to the 5 and 10. This isn't really a variance. This is a request to have the same allowable width that was granted in phase 1 and phase 2 to be granted in phase 3. We wouldn't be conforming. In fact, I suggest that this phase 3 might look like you drop a bunch of shipping containers onto it. All that you would see is a garage. You know, if you can picture, and I have some documents here that I'm happy to leave behind. We've done some renderings to show you what an impact looks like. And I'm not suggesting for a minute that if we should go to the building envelope that's typical throughout the regional district, that we're going to exercise a full footprint. There's other regulations, and we're showing a typical house plan that we've developed, and it takes up about 45% of the land mass. So that's the request here, is to simply be conforming with the first 2 phases and to be able to have someone come in and build a home that for their investment of the land and the cost of the building can appreciate some value out of it. So if you want to go drill down a little further, I'll give you an example. If you were to build a 16-foot wide home and you take out 4 feet, which is an outside wall, a 3-foot hallway, and a 4-inch inside wall, you're left with 12 feet. You could never have anything but a single 12-foot room on one side of a hallway. You're going to build a mobile home park. And that's no longer the zoning for this particular property. RR5 has changed that.
Thank you.
Yep.
I turn to the director of the area, and also Director Wilson wanted to,
Thank you.
Director Acton.
Mr.
Dale Bellavance.
Bellavance.
I'm the agent for the company that owns the property.
Is that a question?
Okay, no,
For
I'm
the
getting
agent?
there. I know,
I'm sorry, I was so enamored with the
So-
director, I forgot to introduce
Good one.
myself.
I totally agree with you on the width, and so does the commission when they looked at your application, and I was there when you presented, and, for most of it. And I get it. I think it does, that variance needs to be approved. And I think you can build a better house, like you're saying. You probably have, the building materials are probably laid out that way. You know, it's all kind of set out, and that's how it has been explained to me by another builder. So I approve that. The one thing I hear you saying, you know, you're coming in with some improvements with the wastewater system, and I've heard that from the beginning, and I think that's great. And I think you can even go a little further of improving. I made some phone calls to people in the other area. One person has no kids, just has an older daughter. And I made another phone call to somebody in phase 2 who does have kids. And I have actually spent a lot of time in that area. It is a great neighborhood, but I think it can do a little better. There is no green space. There is, and this requirement for the common storage, their point was it wouldn't be so bad to have that, but green space would be better, just as the commission has recommended. So I'd like to see something. When I've been there, the kids are playing on there's no sidewalks. Kids are playing on the street, which is fine. It's pretty slow traffic. They're having a great time, but it would be nice to have a little bit more. And I know there's some park areas designated, but they are the worst pieces of land. That's why they've been given. And one's like on the other side of the tracks, or we're gonna get kids to play on this little piece over by the tracks. I just think that it can do better, and we can create a better sense of community so that we're not doing what we've had to do from the other phases, is trying to improve it later. So
Do you have a different
that's,
resolution?
well, I would like to see staff work with this developer.
So are you
and-
actually, is this a referral motion, or do you have another option of another
Unless
recommendation?
the applicant has something to add, it might be. Like, I would like to see the wishes of, I would like it to have more of a green space, and I do not approve the common space being waived.
I'm not sure if we're going to be negotiating that at this table. I think the fairness is you should be either referring or go for the recommendation that the staff has already come with. So I'm looking to the group. I do have Director Wilson on my list. Director Wilson?
Thank you, Madam Chair. I've never been much of a salesman, but I've got to commend you on your skills. That's
Well, I'm not sure where they came from, but I do spend a lot of time working on behalf of municipal government
yeah,
as well.
yeah.
So.
No, I don't see any problem with this at all. I would recommend that the number 2 there be approved. We're not talking, I'm sorry to say this, Director Acton, we're not talking about green space here. We're talking about places for people to live. We already have a housing crisis, and to give more or to ask for more land and then if the kids are happy playing in the street right now, why not let them? That's what I used to do. And if the traffic's slow, let them play there. But give the people somewhere to live, first of all. So basically, all I'm saying is I would like to see all 3 of these go through, but with the amendment that number 2 is approved.
Is that a motion? Okay, so you are moving all 3 recommendations with approval instead of denial on number 2.
Yes.
Okay, is there a seconder for that motion? Director Morrison, did you just second the motion? No? Is there a seconder for that motion? Seeing none. Moving back to the original motion. Director Morrison.
Yeah, I had some of the same questions that have been raised. I think that green space is important. I think that that this isn't quite as developed to the point where the director can support it. So I would move that this be referred to staff to attempt to address the concerns expressed by the director, and that it come back to the next EASC meeting.
So this is a motion to refer. It's been seconded by the director of the area. It has been seconded. So on the referral, I did have you on the list, Director Nicholson. You don't want to speak to the referral. Anybody on the referral? Seeing none, I'll call the question. All in favor of referral? Been moved and seconded. Thank you. It's been approved for referral. Point of order. Oh, hold it.
You didn't call for those opposed.
Oh, anybody opposed, if any? Sorry. Oops, slipping. Now that I got that little pat on the back, you know. Carry my head. Okay, then we'll move on now to any unfinished business.
Thank you, Madam Chair. There is none.
New business, there is none. Question period. Questions shall be addressed to the chair and must be truly questions and not statements of opinions. Welcome again.
Thank you, Madam Chair. So Director Acton told me that the staff has informed her that having thousands of cubic meters of hog fuel on the site.
No, that's not, is that a question for the chair? It has to be, you're here,
Yes,
this
yes.
is question
So-
period,
So that's the background. So my question is, when the soil bylaw states clearly, and the Ministry of Environment regulations state clearly, that you cannot deposit more than 100 cubic meters of things such as hog fuel on a site without a permit, why is this being allowed on the Goldstream Heights landfill site?
I'm not familiar with that exactly, and I can't speak to that. You could check with the province or somebody else. Is there any other questions?
Good afternoon, Madam Chair. I'm sorry, I didn't have an opportunity to review the cannabis file prior to the meeting, but I just wanted to ask about the farm gate sales. The farm gate sales, this is an agricultural product that is a controlled product, and it's not like fruits and vegetables that you would be buying from a local producer. And I just have some concerns about that, and I will look forward to hearing what happens
Thank you so
moving forward.
much.
Move to resolve into closed.
Oh, there's another speaker. Mr. Evans.
Madam Chair, under 7.3 of the 4236 bylaw of soil deposit bylaw, it states in there that no person shall cause or permit the deposit of other material, and I read out that definition of other material before.
Yes.
And its hog fuel is included on any parcel within an electoral area except as permitted under a facility license issued in accordance with CVRD bylaw 2570 waste stream
Your question?
management. So why can't the CVRD look after this?
I believe they are looking after it.
You're just wonderful. Thank you.
Great.
Sure.
Good. Glad to be of help. Okay, we're going to motion to go into closed. So moved. Second. Was there another speaker for the podium? Sorry, I didn't want to exclude anyone. Seeing none. A motion to go into closed. It's been moved and seconded. Is there a seconder to go into closed? Didn't see one. Hands up. There we go. Thank you. All in favor? Any opposed? Motion's carried. 5-minute recess for we close the doors and the gallery empties. Thank you. I saw sort of too. I actually saw.